rise. During the oral pleadings, both applicant and respondent are each allocated a total of 45 minutes to deliver their arguments. The 45 minutes shall cover the pleadings of the first and second oralist, and including the rebuttals and surrebuttals. The applicant begins first with their main pleadings, followed by respondent. Afterwards, applicant will once again deliver its rebuttal and followed by respondent's surrebuttal. The judges are allowed to ask questions during the entirety of the oral pleadings.
Mr. President, Your Excellencies, may it please the Court.
The third issue is whether Ravenia acted lawfully in issuing fishing licenses over the Triton Shoal, given rising sea levels and shifting baselines in the Paine Peninsula. By 1980, the Paine Peninsula states defined their baselines as ambulatory, with exclusive economic zones measuring Ambrosia froze its baselines at the low water line. Ravenia says that the practice in the Paine Peninsula is to follow the ambulatory nature of baselines, but all other 6 states followed Ambrosia and fixed their baselines. 2018 came in the area where majority of the marine resources could be found. The Triton Shoal fell outside Ambrosia's exclusive economic zone. Ravenia issued the fishing licenses, claiming that the shoal is now within the high seas. Both sides will approach this issue from a standpoint of treaty interpretation and application of customary international law.
Each applicant and respondent must present their case before the International Court of Justice. 9 matches await in this round. Each one a battle of wit, skill, and strategy in international law. Who will present the stronger case? Who will convince the court? The stage is set. Before the International Court of Justice, the applicant, Arellano University, versus the respondent, University of Santo Tomas. Now, applicant begins with its submissions.
Madam President, Your Excellencies, good morning. And may it please this honorable court. My name is Billy J. Rodriguez, second agent for the applicant, the Union of Ambrosia. Ravenia violated international law by issuing fishing licenses on the portions of the Triton Shoal within the exclusive economic zone of the Union of Ambrosia. It is no question that the most contentious issue in this case is whether or not the portions of the Triton Shoal is really within the exclusive economic zone of the Union of Ambrosia. This exclusive economic zone is measured starting from the low water line under Article 5 of the UNCLOS, reaching 200 nautical miles outwards towards the Aegean Sea, Your Excellencies.
Agent, what is your basis for claiming that the freezing of the baseline is the standard established by the UNCLOS?
Your Excellency, it is the position of the Union of Ambrosia that the freezing of the baseline is first in conformity of UNCLOS based on the treaty interpretation under the VCLT, and second, that it is a customary international law.
Agent, you're not answering my question. I am asking what is your basis for, and if whatever that basis is, why are you considering it customary international law?
I understand, Your Excellencies. Under Article 38, Paragraph 2 of the International Court of Justice Statute, it provides that one of the sources of international law is the general custom, Your Excellency.
What are we talking about? You have not answered my first question. what are you using to support your freezing of the baseline?
First, Your Excellency, what we are using, Your Excellency, is first the general custom as basis.
You're not answering the question. What is your basis for saying that the freezing is there? What principle for you to determine? What is the principle that you are using to determine where you determine your baseline?
To determine the baseline, Your Excellency, we use Article 5, which is the normal baseline. And based on Article 5, it states that the start of the measurement of a baseline is on the low water level.
You are not answering my question.
We do agree that we have submitted...
Answer the question. The question is simple. When you created domestic legislation in 2015, what was your basis for using? What was the reason? What was the rationale in determining your baseline?
Yes, Your Excellency, the updated charts that have been submitted based on the clarifications on paragraph 4, that when the Union of Ambrosia issued its domestic legislation, it also submitted the chart that I've mentioned based on Article 5.
What is the basis for that chart? Where do you measure?
Based on the treaty interpretation, Your Excellency, we submit that in its ordinary sense and also in light of its object and purpose, it is our submission that first, in the ordinary sense, in Article 5, there is no sign, Your Excellency, there is no interpretation that the baselines should be ambulatory.
Okay.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
I am Jerome Rafael Austria, the second agent for the respondent, the Republic of Ravenia. At the heart of this case is the principle of legal certainty in the law of the sea. The applicant seeks to depart from the well-established principles under the UNCLOS by freezing their maritime baselines, despite the treaty's clear requirement that baselines be measured at the low water mark. And such a departure could introduce instability among established maritime entitlements, which may disrupt the predictability that is relied upon by all coastal states.
Insofar as their baselines are concerned, there is a growing practice amongst especially affected states as well that have frozen their own baselines. And so in reference to this, if we follow the VCLT insofar as how we are supposed to interpret the treaty, then it would seem to suggest that even growing custom or subsequent custom can change the interpretation of the terms itself of the UNCLOS.
Your Excellency, Madam President, allow me to submit that Ambrosia's reliance on treaty interpretation by way of contextual interpretation of Article 5 of the Convention is unavailing under international law. First, Article 5 is already explicit that baselines be measured at the low water mark, and there is no explicit provision in the Convention that highlights or that states that freezing of baselines is allowed. We submit that a textual interpretation is needed in this particular instance. But in light of sea level rise, we still maintain that an ambulatory interpretation of Article 5 is still the legally sound and the equitable solution for sea level rise experienced by these coastal states.
The respondent wins the match. Next, the applicant, Aklan Catholic College, versus the respondent, University of St. LaSalle.
Madam President, Your Excellencies, may it please the Court. My name is Kenneth Lanoy and I appear as the second agent for the applicant, the Union of Ambrosia. Ravenia's issuance of fishing licenses within the 200 nautical miles of Ambrosia's fixed baseline is not in accordance with the UNCLOS and violates the international law. Article 7 allows for a flexible interpretation of the baseline, which is shown on charts of adequate scales and publicized by the coastal state, which must also be deposited a copy to a UN Secretary General.
But Agent, when does Article 7 apply?
Article 7 apply, Your Excellencies, in the straight line baseline method.
Yes, but when are straight baselines applicable? In other words, is it not clear on the facts that your states use the normal baseline method?
We do acknowledge, Your Excellencies, that although straight line baseline is normally applicable to archipelagic state, and the Pain Peninsula, wherein the Ambrosia and Ravenia is not a archipelagic state. But what I'm trying to point out, Your Excellencies, is before the adoption of the UNCLOS in 1980, this court has ruled in the Anglo-Norwegian fisheries case in 1951, wherein there is no state line baseline before. In the Anglo-Norwegian fisheries case, this court ruled that the Norwegian decree allows for a 1,000 coastline along the marks to protect the interest of the coastal state.
Yes, but as you said, that was before the UNCLOS was adopted. Now we have a treaty.
Yes, Your Excellencies. And based on that, Your Excellencies, it is our submission that this court has previously deviated from the definition of the normal baseline.
Deviated?
Yes, Your Excellencies.
Was there already a treaty applicable?
Your Excellencies, during the time of the decision of the Anglo-Norwegian fisheries case, there is no definite treaty and it's already part of a
So how can you say there is a deviation?
Yes, Your Excellencies. It is our position that there is deviation because in 1951, prior to this Anglo-Norwegian fisheries case, what has been followed is the state line baseline method to measure the exclusive economic zone limits, which must be the 200 nautical miles along the baseline. The issue in that case is how about the archipelagic state that could prejudice their own maritime rights and consider in between of that state to be considered as a high seas. That's why this court has previously made a liberal interpretation that for the state to protect their own sovereign rights, they have adopted a new baseline, which is the state line baseline method.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
I am Alexa Gray Maderazo, second agent of the Republic of Ravenia, the respondent in this case. Your Excellencies, the actions of Ravenia are embedded in the principles of international law, guided by the obligations to uphold treaty commitments and respect state sovereignty.
State practice must be widespread, consistent on the affected states, right? I mean, obviously, we're not including the practice of landlocked countries insofar as freezing baselines are concerned because they don't have baselines. But there is a growing number of states who are actually passing legislation basically declaring that they are also freezing their baselines. Are you aware of this, agent?
Indeed, Your Excellency. However, this case is unique in the sense that Ambrosia has consistently objected in such manner, and even
you mean Ravenia, respondent?
Ravenia has consistently objected in such manner, and even though such the freezing law may be passed as customary international law.
How are high seas treated under the UNCLOS, agent?
High seas under Article 58 of the UNCLOS, Your Excellencies, high seas are treated with such freedom, Your Excellencies.
Common heritage of mankind, right?
Indeed, Your Excellencies.
So no one actually has any kind of control in relation to the high seas.
Indeed, Your Excellencies. However, if Ravenia adopted the freezing law, Your Excellencies, it will be now become a part of the EEZ of the Ambrosia, Your Excellencies, which will impede on 40% of our fishing industries. As such, it implies that Ravenia is effectively and specifically affected by such imposition.
The applicant wins the match. Up next, the applicant, Cagayan State University, Cari, facing the respondent, LaSalle University, Tanyada Jokno.
I am Jared Garen Somera, the second agent for the Union of Ambrosia, the applicant in this case. Ambrosia's freezing baselines law is valid, but Ravenia's issuance of licenses to fish and revoking those existing licenses in those parts violated the international law.
Are the coastlines involved in this case deeply indented, or isn't it already an agreed upon fact that the baselines are actually normal baselines?
Your Excellencies, while we concede to that fact, we submit that, Your Excellency, while we concede to that fact, we submit that
If that's a concession, agent, I don't think we should bother discussing it. The baselines are normal. So actually, the jurisprudence that you are citing is not applicable.
Your Excellency, while we do concede that the fixing of baselines is not the most common view under UNCLOS, the applicant submits, Your Excellency.
So it's not the most common view, and therefore it's not custom.
Your Excellency, we submit that in this case, it has ripened into customary international law because under the statement of agreed facts, the other member states also adopted the freezing baselines.
So it's a regional custom.
Yes, Your Excellency, we submit to that, Your Excellency.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
My name is Justin De Borja, the second agent for the respondent, the Republic of Ravenia. Your Excellencies, on the third issue, preliminarily, we provide that it is not Article 7, Paragraph 2, contrary to the submission of the good counsel for the applicant that applies to this case. Your Excellencies,
The low water line as mapped by the coastal state.
yes, Your Excellencies.
And so if the state by its municipal law stops mapping, then that's it.
Well, Your Excellencies, we take a different position on the matter, given that while there is no frequency required for states to update its map, there is likewise no provision that allows it to permanently fix the low water line. Your Excellencies, we recognize that in Article 5 provides some discretion that is afforded to the state to determine its large-scale chart. However, Your Excellencies, an examination of the Travaux Papertois in the 1930 Hague Codification Conference, Your Excellencies, it reveals that what is afforded as to the discretion of the state is to determine the mode to determine the low water line, but not what the low water line is.
The respondent wins the match. The elimination round will continue when the JESSUP 2025 Philippine Round Journey returns. The competition continues. Up next, the applicant, University of San Carlos, taking on the respondent, University of San Jose Recoletos. Applicant begins with its submissions.
Mr. President, Your Excellencies, good day and may it please the Court. My name is Mel Joseph Castro, respectfully appearing as the second agent for the applicant, the Union of Ambrosia.
Wait, give me a roadmap first. What are the principal arguments that you're gonna make instead of going through this entire context?
Certainly, Your Excellency, the arguments of the applicant under the third submission is that first, the baseline freezing law is consistent with the United Nations Convention on the Law of the Sea. And second, that Ravenia violated its duty of cooperation under both UNCLOS and the OCDP Charter. Turning to the first argument, Your Excellencies, the baseline freezing law is consistent with other practice of states across the world. For instance, Tuvalu in 2012, Kiribati in 2014.
Is issuing licenses regardless of the question on the baselines. Can a state issue fishing licenses in the high seas?
No, Your Excellency. However, it is applicant's position that this part of the Triton Shoal remains with the exclusive economic zone of Ambrosia, and thus this would have to deal with the question on whether the baseline freezing law is consistent with the provisions of the UNCLOS. Your Excellencies, the fixing of baselines is not prohibited by the text of the UNCLOS.
But is it expressly allowed by the UNCLOS?
No, also, Your Excellency. However, in the absence of an express prohibition, states may exercise their sovereign discretion. Article 5 of UNCLOS, Mr. President, in that baselines must be established at the low water
If
line.
verbalege is silent, what is our next route for statutory construction?
We may look into the context of the treaty.
Right. During the deliberations for the 82 UNCLOS, was the question of receding baselines of global warming even conceived by the framers of the UNCLOS?
No, Your Excellency, and thus it would require instead to a resort to the subsequent practice of states and the application of UNCLOS that would establish the agreement of states.
So the UNCLOS is a living document like the Philippine Constitution.
We submit that yes, Your Excellency, UNCLOS must be treated as a living instrument in order to address the evolvement of the needs of its member states.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Mr. President, Your Excellencies, good morning and may it please this honorable court. My name is Ivy Joy Havagat, second agent of the Republic of Ravenia, the respondent in this case.
Can you explain to me the principle of complementarity and why complementarity in your arguments is not applicable in this case?
The principle of complementarity is, what was the wording again, Your Excellency? The principle of complementarity is not applicable in this case, Your Excellency, because we, under our submissions, that the conventional law applicable in this case, which is UNCLOS, is clear that the normal baseline is the actual low water line in this case. We submit, Your Excellencies, that the provisions of UNCLOS shall be interpreted using two approaches. First, the contextual approach, and second, the subsequent practice approach. The contextual approach refers to the interpretation of a provision in light to the overall text of a treaty, ensuring that each provision is in coherence with other provisions of the treaty as a whole. This is in line with Article 31, Interpretation of Treaties of the Vienna Convention on the Law of Treaties. Your Excellencies, we submit that Article 5...
How does the UNCLOS define what a normal baseline is?
Yes, Your Excellency, which is why in Article 5 of UNCLOS that provides except where otherwise provided in this convention, the normal baseline for measuring the breadth of the territorial sea is a normative and indispensable reference point for all subsequent maritime measurements.
How relevant is the UNFCCC discussions in practice here, ma'am? What weight do we impose on the UNFCCC discussions?
We take into consideration the UNFCCC discussions, Your Excellencies. However, it is our submission that under conventional international law, specifically UNCLOS, the normative standard should be Article 5, the measurement from the low water line along the coast. And while we consider the discussions in the UNFCCC, it is our submission that Article 5 prevails and it should be the normative standard for the baselines.
The applicant wins the match. Up next, the applicant, Silliman University versus the respondent, Tarlac State University.
My name is Vince Melodia, agent for the applicant, the Union of Ambrosia. Your Excellencies, Ambrosia enacted its freezing law in response to the report of the Intergovernmental Panel on Climate Change that the coastlines in the Paine Peninsula are receding at an average of 1.5 meters annually, with Ambrosia being the most affected. And Your Excellency...
I just have a question. So Ambrosia claims the Triton Shoal is within its exclusive economic zone EZ, right?
Yes, Your Excellency.
Okay, this is based on the freezing laws you have mentioned, but if UNCLOS does not explicitly permit the fixing of the baselines, why should the court accept Ambrosia's position that over the prevailing ambulatory baseline doctrine?
We understand your concern, Your Excellencies. The International Law Commission and the International Law Association, in their reports in 2023 and 2024, in recognizing the challenges posed by climate change and sea level rise, recognize the customary nature of fixing baselines in accordance with UNCLOS, and suggested that other states facing similar challenges should adopt the same. Here, Your Excellencies, the applicants did not violate UNCLOS in delimiting its baselines because first, under paragraph 13 of the compromise, it shows that Ambrosia's baselines are its low water lines. pursuant to Article 5. And second, under paragraph 3 of the clarifications, Ambrosia did submit the charts to its baselines with the Secretary General, and they were duly accepted.
So, Agent, this argument applies despite the point of the respondent and the report that the shoal is actually found in the high seas.
Your Excellencies, the applicants disagrees with the contention that the shoal is part of the high seas due to the fact that the charts to Ambrosia's baselines, which are submitted to the Secretary General, includes the Triton Shoal within Ambrosia's EEZ or within 200 nautical miles from Ambrosia's baselines, Your Excellencies.
Agent, what is the purpose of depositing copies of these with the Secretary General?
These are publications, Your Excellencies, to allow other states to be notified of the status quo of the coastal states' rights and duties, Your Excellencies.
And then, is it possible for other states to, let's say, issue a note verbal contesting it, protesting against what is declared by one state to be their baselines?
Yes, Your Excellencies. The note verbal does not have any legal effect, as under UNCLOS, other states are given the choice of bringing the dispute to the ITLOS, to this honorable court, or to any arbitration tribunal. And in this case, Your Excellencies, the protest of Ravenia with regard to Ambrosia's set baselines have no legal effect under international law.
Under UNCLOS, when there is a definition of the maritime zones, is it ambulatory based on the definition of the Law of the Sea Convention?
UNCLOS, Your Excellencies, did not specifically state that baselines should be ambulatory or fixed.
If you could recall the provision on the determination of what is the EEZ, from where is it measured?
It is from the baseline, Your Excellency, 200 nautical miles from the baseline of the state.
And so in this case, hasn't the baseline of the Union of Ambrosia already moved?
We understand this concern, Your Excellencies. However, it is the baseline submitted with the Secretary General that should be respected.
So following this train of thought, any state, they can declare my baseline is now here, and as long as it's deposited, this is fine, even if other neighboring states are contesting against it?
Not necessarily, Your Excellencies, as the initial measurement of the baseline must be in accordance with UNCLOS, as what Ambrosia did, Your Excellencies. The normal baselines of Ambrosia were indeed the low water lines of Ambrosia, and then they submitted it with the Secretary General. And the charts, Your Excellencies, should be respected.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
I am Daria Nodon, the second agent of the Republic of Ravenia, the respondent in this case.
Agent, does the Law of the Sea Convention forbid freezing of baselines?
No, Your Excellencies, the UNCLOS did not forbid the freezing of baselines. As a matter of fact, the general rule can be seen in Article 5, which discusses the ambulatory nature of baselines, which means that it will always reflect the low water lines along the coast. We have exceptions to the...
Wait, that's a contradiction. So, does the law forbid freezing?
No, Your Excellency, it does not forbid freezing of baseline.
So it allows?
It allows the freezing of baseline, Your Excellencies, as we have exception to the normal baseline, which is known as the straight baseline, which can be seen on the Article 7 of UNCLOS. However, it can only be applied under specific circumstances. For example, when the state is archipelagic in nature, which is in this case, it is not applicable since Ambrosia is part of the Paine Peninsula. Second, it is when the state is deeply cutted or intended, or there is a presence of delta, wherein in this case, it is also not applicable, as a matter of fact.
What's your basis for saying that under those instances can you freeze? Under only those instances can you freeze?
Under only these instances that one state or coastal state may freeze baselines, Your Excellencies, because it is expressly provided on the said convention. That without these circumstances, then we must follow the nature of the normal baseline, which is ambulatory.
So isn't it true, Agent, that you're trying to say to us that if there are some exceptional cases, then there could be fixing of baselines, correct?
Yes, Your Excellencies.
So your counter, Ambrosia here is arguing that there's a developing practice amongst the states on fixing baselines on the reason of climate change. Shouldn't the court consider that as an exceptional circumstance warranting the fixing of baselines?
No, Your Excellencies. They cited earlier the Pacific Islands Forum, which aims to fix the baseline, but it is not yet a state practice, but rather a suggestion and declaration to fix baseline because of climate change and because of the existing sea level rise. However, the applicant may contended earlier that they may apply a straight baseline when there is a presence of any natural conditions that makes the coastline highly unstable. So assuming arguendo that they put forward that claim or that argument, it is still our submission that Article 7, Paragraph 2 of UNCLOS, or the presence of any natural conditions, is not applicable to them as there is no fundamental change of any circumstances.
The applicant wins the match. Next, before the judges, it's the applicant, University of Batangas, versus the respondent, Jose Rizal Memorial State University.
Your Excellencies, the applicant respectfully submits that Ravenia's issuance of licenses to fish within the Triton Shoal within 200 nautical miles of Ambrosia's fixed baseline pursuant to their freezing law violates international law.
We allow you to fix your baseline even if a coastline recedes. That means that you will also have an increase in your territorial sea. Would you not agree? Or actually your internal waters?
Your Excellency, we agree that in fixing the baseline and in the increase of sea level rise, the internal waters of the Union of Ambrosia may increase. However, Your Excellency, in the rise of sea level, the landmass of the Union of Ambrosia would decrease, Your Excellency, and the internal waters wherein the coastal state exercises the same sovereignty as a sovereignty over their land, this would not prejudice the state of Ravenia, Your Excellency.
But you would agree that the UNCLOS, however harsh it may be, is not concerned on whether land will decrease, correct? That has been the ruling of many tribunals, in fact including the South China Sea arbitration, right?
Yes, Your Excellency.
So the only balance that it has to make is between the right of the coastal state on one hand and the right of other states also with regard to preserving their concomitant right to also exploit resources outside the national jurisdiction of states, right? So don't we also have to look into the fact that other states' rights can also be diminished when you recognize yours, Agent?
Your Excellencies, we respectfully submit that in fixing of their baselines, the Union of Ambrosia does not prejudice Ravenia in claiming that the Triton Shoal is within their EEZ. Since, Your Excellency, the Triton Shoal had been part of the EEZ of the Union of Ambrosia, and the Triton Shoal, if the fixing of baselines would not be made by the Union of Ambrosia, would be totally outside its EEZ, and therefore the Union of Ambrosia would be the one to be prejudiced, Your Excellency. The fixing of baselines made by the Union of Ambrosia does not in any way expand their maritime zones, nor deprive Ravenia of their existing maritime zones, Your Excellency.
That is the effect, Agent, right?
Yes, Your
If you
Excellency.
retain your current outer limit of the EEZ,
that means that you will have an expanded internal water, something that did not belong to you in the past, right? So that would also, would you agree, prejudice the ability of other states to enjoy that portion of the water?
Your Excellency, the addition of the internal waters of the Union of Ambrosia, if the sea level rise would continue, it does not prejudice the other states, Your Excellency, since such territory, Your Excellency, had been within the enjoyment of such state, Your Excellency. And the applicant respectfully submits, Your Excellency, that the Union of Ambrosia does not violate the UNCLOS, since the UNCLOS only gives the requirement to a coastal state to submit large-scale charts with the United Nations Secretary General. And in this case, Your Excellency, based on the clarifications to the Statement of Agreed Facts in paragraph 3, the Union of Ambrosia fully complied with such requirement. And the UNCLOS does not provide for a requirement for the coastal state to regularly update the fixing of their baselines, Your Excellency.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
My name is Rica May Soronda, the second agent for the Republic of Ravenia, the respondent of this case. The applicant's submission claiming that Ravenia's issuance of licenses in parts of the Triton Shoal rests on were in violation of international law, rests in the assumption that these parts of the Triton Shoal is still within their exclusive economic zone. The receding coastlines due to sea level rise do not alter the essential basis of the consent of the parties to be bound by the stipulations of the UNCLOS.
Is that not radical, Agent? The fact that today, well, before, the other party could exclusively claim all the rights in that water, but now they have no choice but to recognize the deluge of, let's say, fishing vessels that might go there.
As based on scientific researches, Your Excellency, receding coastlines or sea level rise rather is not a radical change. It's not a radical change enough to be considered a fundamental change in circumstances, since it was already foreseen even in the late 90s. Even the drafters of the UNCLOS have considered the possibility of sea level rise, Your Excellency.
What does the word radical in the BCLT qualify? Is it the fact which changed the obligation or the level of obligation? What do you think?
The extent of the obligation.
The obligation, right? So isn't that a 360-degree turn, Agent, from being solely having the right over the waters, except of course they need to recognize the rights of other states, to now being forced to recognize the rights of all states to fish in that area? Is that not a radical change in the obligation?
No, Your Excellency, because even following the receding coastlines, among other rights, the states will still enjoy an exclusive right up to 200 nautical miles from that baseline that was already fixed, that is fixed from after the recession of the coastlines, Your Excellency.
Because they still have their own 200, right? But as far as the Triton Shoal, Agent, which I think based on the facts would now have a lot of fish in that area, does not that impose upon them some radical obligation, because they're now forced to allow states like you to go there?
Your Excellency, given that, as you have said, Your Excellency, that and provided in the compromise that this significant concentration of tuna species have already migrated in the Triton Shoal, that would also
given if we allow Ambrosia to fix their baselines, that would also impair or infringe the rights of the states over those marine resources, which are already supposed to belong in the high seas. And I would also like to highlight, Your Excellencies, that all the states in the Paine Peninsula, including Ravenia, are highly reliant on those tuna species, which are highly migratory. So if we allow Ambrosia to exclusively have the right to fish, pertaining to Triton shoal, then that would infringe their right over those marine resources.
The applicant wins the match. The final set of matches is coming up when the JESSUP 2025 Philippine Round Journey returns. The competition continues. Next, the applicant, University of Cebu, Banilad, taking on the respondent, Ateneo de Zamboanga University. Now, applicant begins with its submissions.
Madam President, Your Excellencies, good day, may it please the Court. I am Aliana Mabelin, second agent for the applicant, the Union of Ambrosia. Your Excellencies, under the third issue, we have two submissions. First, that certain parts of the Triton Shoal are within Ambrosia's exclusive economic zone, wherein Ravenia has no right to fish. And second, that Ravenia has to observe due regard and to comply with the laws and regulations of Ambrosia pursuant to Article 58, Paragraph 3 of UNCLOS.
But Agent, is it also true that it is undisputed that currently the Triton Shoal is beyond the 200 nautical mile demarcation from the territorial sea as determined by the actual low water line of the coast? Shouldn't the actual low water line be the determining factor for the delineation of the exclusive economic zone?
Your Excellencies, that is the position of the respondent. However, in the International Law Association's report during their Sofia conference in 2012, they stated that Article 5 of UNCLOS, Your Excellencies, has always been ambiguous. Article 5 provides that the normal baseline is the low water line along the coast as marked on large-scale charts officially recognized by the state. And the dispute in this case, Your Excellencies, lies in the interpretation of such provision. Because the first interpretation, Your Excellencies, is that the low water line referred therein is the charted low water line or the baselines as reflected in the nautical charts officially recognized by the state. The second, Your Excellencies, is that the low water line is the actual low water line, as said by Judge Redoble, that it can vary at any given time because of tidal fluctuations. And in this case, Your Excellencies, the applicant is taking the position of the first interpretation, which is supported by the conclusion of the International Law Association during their Athens conference in 2024.
What was the basis of their conclusion?
Your Excellencies, the basis of their conclusion was the emerging state practice of UNCLOS member states. The applicant is submitting that there are already multiple states. For example, Ireland, Your Excellencies, has affirmed that legal baselines should remain in place to maintain stability, Your Excellencies. And the United States also echoed this in their 2022 policies, wherein they committed to maintaining maritime zones despite sea level rise. And this is also evident, Your Excellencies, in regional declarations by the Pacific Island Forum and Alliance of Small Island Developing States. The Pacific Island Forums has 18 member states, 16 of which are members of UNCLOS, and the Alliance of Small Island Developing States has 39 member states. Therefore, Your Excellencies, there has already been substantial state practice that served as the basis of the ILA, which is permitted under the Vienna Convention Law of Treaties.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
My name is Ryan Kaiser Sakir, the second agent for the Republic of Ravenia, the respondent in this case. At the outset, the respondent would like to point out that we do not contend, nor in fact we concede that the applicant has the right to determine its exclusive economic zone in accordance with the UNCLOS, and that it has the right to exercise and enjoy its sovereign rights within such zone.
Just to clarify,
Yes, Your
when you
Excellency.
say that the fixing or the freezing of baselines finds no support in the UNCLOS, is it only in relation to this case, or is there absolutely no authorization for the freezing of baselines under UNCLOS?
To clarify, Your Excellency, our position is simply that the fixing of baselines in response to threats of sea level rise finds no support under the UNCLOS. We acknowledge, Your Excellency, that under certain articles in the UNCLOS, particularly under Article 7, Paragraph 2, it allows the fixing of baselines, but only under certain conditions, Your
And what are
Excellency.
those conditions?
Well, for the such condition is relates to the application of the straight baseline, such as when the geographic features of a coastal state is deeply indented into, or there are fringes of island along such coastal state, Your Excellency.
Would you agree with the interpretation that the UNCLOS is a living constitution and therefore its interpretation should evolve with the times?
We have to disagree with that, Your Excellency. We are of the position that to avoid the undermining of the legitimacy of the UNCLOS, it would be better for a subsequent amendment to the provisions of the UNCLOS to cater to the threats of sea level rise rather than a mere reinterpretation of its provisions, Your Excellency.
The respondent wins the match. Next, before the International Court of Justice, the applicant, University of San Jose Recoletos, against the respondent, Ateneo de Davao University.
My name is Jabez James Quimido, the second agent from the Union of Ambrosia, the applicant of this case. This case is a tale of two realities. While Ravenia's coastline towers above sea level, Ambrosia is at the mercy of an unforgiving sea. Since 1980s,
does it justify fixing the baselines?
It is our submission, Your Excellencies, under the third issue that our baseline freezing law is valid under three grounds. First, UNCLOS does not prohibit fixing of baseline under textual and purposive interpretation. Second, the consistent state practices of fixing baseline is in the advancement of the enforces of UNCLOS in response to rising sea level. And third, in the alternative, there is a fundamental change of circumstance that justifies Ambrosia's baseline freezing law under the doctrine of rebus sic stantibus. Your Excellencies, it is our submission only that the alleged violation of Ravenia, that we violated Article 5, is not proper because Article 5 is not a source obligation. However, Your Excellencies, we contend that state party members to the United Nations Conventions on the Laws of the Sea must adhere to its manner and mode of demarcating its baseline.
What do you mean by it is not the source obligation? Is it not the source of international law?
We submit, Your Excellency, that the United Nations Conventions is a primary source of international law under Article 38 of this court statute. However, Your Excellency, under the specific alleged article that we violated, we submit to this court that is not a source of obligation. Because, Your Excellency, first, Article 5 does not impose an
But we're not talking about a violation on your part. We're talking about your alleged submission that the respondent violated your essentially rights in relation to the issuance of the fishing license. That's right.
Thank you, Your Excellency. It actually brings me to my submission under the third issue, that Ravenia's issuance of fishing licenses violates Article 56 of the United Nations Conventions on the Laws of the Sea. Article 56 provides, Your Excellency, that the coastal state has the sovereign right to exploit all living and non-living things within 200 nautical miles. Hence, the act of Ravenia's issuance of fishing licenses, as clear in paragraph 22 of the compromise, is an internationally wrongful act as provided under Article 2 on the Articles of Responsibilities for States Internationally Wrongful Act.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
My name is Carl Christian Agunod, and I am the second agent for the respondent. We submit that the Ambrosia's interpretation of baseline under UNCLOS Article 5.
So your position, agent, is that the show is already within high seas.
Yes, Your Excellency.
And what are the rights concomitant to that fact?
Your Excellencies, we recognize that if it is indeed under ambulatory baseline law, the Triton Shoal is therefore included in the high seas, and under Article 87 and Article 116 of the UNCLOS, this includes the right of freedom of fishing and other commercial activities.
Essentially, that does not preclude the applicant from issuing their own fishing license.
Yes, Your Excellency. We submit that this does not preclude the applicant from even fishing in the Triton Shoal. Your Excellencies, we submit on our first point that the interpretation of Article 5 as of the baseline as freezing is not valid or is a unilateral imposition on Ambrosia on Ravenia. It is an imposition upon Ravenia because if the baseline freezing law is enacted or is imposed, it would preclude Ravenia's vested rights to fish in the international high waters, assuming
vested rights.
Vested rights, Your Excellency, it is a right that is already enjoyed by the state, and if Ambrosia's baseline freezing law would be imposed, it would preclude Ravenia, to its detriment, from enjoying such right.
Agent, I am confused. Yes. On the one hand, you're saying that there's no clear interpretation of Article 5. It could be interpreted as either fixed or ambulatory, and in the same breath, by making a fixed baseline, there's already a violation or a deprivation of your vested rights. If there's no certainty with regard to the interpretation of Article 5, therefore, there's no violation on the part of making the baselines fixed.
Your Excellency, we are not submitting that there is a violation on Ambrosia's part in imposing that baseline. We are submitting our argument that Ravenia is not in violation of Ambrosia's baseline freezing laws. We recognize that Ambrosia can set their domestic baseline freezing laws. However, we, as Ravenia, cannot be bound by those laws because it would impair our vested rights. It is a unilateral imposition on Ravenia's part where we had not consented to those baseline laws.
The respondent wins the match. The applicant, University of the Philippines, against the respondent, University of Makati.
Madam President, Your Excellencies, good morning, and may it please the Court. My name is Kimberly Dimaapi, and it is an honor to appear before this Court on behalf of the Union of Ambrosia, the applicant. Your Excellencies, since 1980, Ambrosia's waters, including the Triton Shoal, have sustained the nation's economy and fed its people. However, after 40 years, due to the advent of climate change, sea level rise has threatened Ambrosia's coastlines, and thus, to preserve its maritime entitlements, Ambrosia fixed its baselines. However, Your Excellencies, as the changing currents drew the yellowfin tuna to the Triton Shoal, Ravenia immediately and unilaterally handed over fishing licenses over those parts of the Triton Shoal that are within Ambrosia's exclusive economic zone.
This is the right of the coastal state to its exclusive economic zone absolutely deprives the right of other states?
No, Your Excellencies, under the UNCLOS, states may be allowed to fish within the coastal state CEZ. However, in that case, and as clarified by the Permanent Court of Arbitration in the South China Sea Arbitration, Your Excellencies, such fishing must not be unreported, unregulated, and illegal. And to demonstrate this standard, Your Excellencies, this court, in the case of Nicaragua versus Colombia in 2012, has held that the unilateral issuance of licenses to fish without consultation from the coastal state violates a state's sovereign rights. And thus, Your Excellencies, we can see here that Ravenia committed that exact violation when it unilaterally handed over those fishing licenses.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
I am Rex Jasper Dumagpi, appearing as the second agent for the Republic of Ravenia. We submit that Triton Shoal is part of the high seas, thereby giving Ravenia the freedom associated with the high seas.
But there is such a claim of exclusive economic zone from the applicant. Would it not be prudent to at the very least come up with a consensus so as to avoid proceedings like this from happening?
Well, we consider the claims coming from the applicant, Your Excellency. However, the claim was based on the Ambrosia's baseline freezing law, where in fact this is clearly in contravention of the provisions under UNCLOS as provided under Article.
Doesn't the UNCLOS allow for adaptations based on climate change? Isn't that precisely the rationale behind, one of the rationales behind the UNCLOS as well?
Your Excellencies, we do note that the UNCLOS considers these changes. However, it is explicitly provided under the Article 5 of UNCLOS that it promotes or it encourages the determination of those geographical changes based on ambulatory changes within these coastal lines, Your Excellency. We submit, Your Excellency, that in accordance with the Ambrosia's baseline freezing law, it violates established maritime principles, such as that of the UNCLOS.
Did Ravenia demonstrate its consistent opposition to this freezing of baseline of Ambrosia?
Yes, Your Excellency. It is clearly noted that Ravenia practiced the principle of persistent objector in this case, wherein despite the ongoing provisions or the treaty of the OCDP and the implementation of the baseline freezing law,
The applicant wins the match.
Bawat match, iba eh. Para siyang chess. Di ba? Pareho ng pieces pero hindi mo kasi alam eh. Hindi mo alam kung ano ang mga moves nila.
In JESSUP, it's not about whether you're right and they're wrong. It's about who is more persuasive. So our biggest challenge would be having to refine our materials and researching for the best material and argument possible to support our claims.
As much as we've prepared months for this, there are moments that you really can't predict. And in those moments, you just hope that you've done your best. And we think we've done our best.
So you know that a mooter is a good mooter if he knows how to play by the rules and with a team.
In the next episode, teams present the fourth and final issue of the 2025 JESSUP case. Who will make it to the semifinals? This is JESSUP 2025, the Philippine Round's Journey.